Hi, it's Bill. Today we've got an interesting topic to talk about, divorce and bankruptcy law. With me today is Phyllis Collins. She's a Marietta lawyer and an expert in bankruptcy law. Our program should run about 15 minutes and we'll be posting it on our YouTube channels if you want to see it again or recommend it to any friends or family. At the end of our presentation, we'll take a few questions through the chat box. But let me give you a little bit of background on me. I've been practicing law since I graduated from the University of Georgia Law School in 1986. I concentrate my practice in divorce and family law. I practice primarily in Cobb, Cherokee, Paulding, Fulton, and Bartow counties. Now I'm going to turn it over to Phyllis to tell you a little bit about herself. Phyllis?
Good morning, everybody. Thank you, Bill, for inviting me to join in this webinar. It's an honor and privilege to be with someone who's such a legal expert in the field of divorce. I have a practice called Phyllis Law, and we practice in criminal defense, student defense, and also consumer bankruptcy protection. And today I'm going to be talking to you about when bankruptcy and divorce collide.
Wonderful. Well, over the last month, COVID-19, the coronavirus, has been wreaking havoc across our country, including the metro Atlanta area. It's been sickening hundreds of thousands of people in the U.S. and killing thousands of its victims. As a result of the necessary social distancing, the virus has forced thousands of small businesses to greatly reduce their hours and even close. This has caused millions of people to be laid off or had their hours reduced and their incomes cut. Unfortunately, all of this is likely to get worse before it starts to get better. These developments have been impacting people who are divorced or who are going through divorce because this drop in people's incomes is affecting people's ability to pay child support, alimony, and their other bills. What can you do if you are owed child support or alimony and your payment doesn't come? This is something we've been getting a lot of phone calls about recently. First, be reasonable. Reach out to your ex-husband or ex-wife or your child's other parent who owes you that support. Tell them that you haven't gotten your payment yet. There might be an innocent explanation. In other words, communicate with them first. If doing the communication way doesn't work, then you can and should consider filing a motion for contempt. Now, a motion for contempt is simply a request for the judge to hear your situation, to hear from both parties, and make a decision. Many times we file a motion for contempt, and that motion issue can be settled without having to actually go into the courtroom. What should you do if you owe child support or alimony and you have no income? Again, be reasonable. Reach out. Communicate. Perhaps the most important thing if you owe child support or alimony is to always pay something. Never just pay nothing. This will infuriate the judge. You can file papers, if that route doesn't work, asking the court to reduce your child support or your alimony obligation because of your reduction in income or losing your job. Again, most of these cases settle without the need to have a contested hearing in front of the judge. But remember that the judge has the power to put you in jail for not paying your support if the judge feels that you can pay, but have simply chosen not to. That's why it's important to always pay something. Now, Phyllis, can bankruptcy help people in situations like the ones we've been talking about, or maybe where debts have been divided in a divorce case and they're not getting paid?
So, Bill, that's a really good question. I want to start with the issue of support. I want to make sure everybody understands that child support and alimony are non-dischargeable in bankruptcy. So a lot of times a spouse will panic when the other spouse files a bankruptcy, worried that they're not going to get their support payments, when in fact, those are non-dischargeable debts. So bankruptcy will not protect them from having to pay those. It may be, though, that there's going to be a temporary period of time where they're not going to get their payment. Because once a bankruptcy is filed, the automatic stay goes into effect. What the automatic stay says is that there can be no further action to collect on a debt during the pendency of the bankruptcy. Now, really good divorce attorneys like yourself know what to do. You know that you can file for a relief from the automatic stay to go ahead and try to proceed with certain types of things. But usually the judges do stay away, the Superior Court judges who hear divorce cases and contempt actions do stay away from ruling on cases that are in a bankruptcy. So that's one thing that you need to be concerned with, but don't panic and think that the ex-spouse is going to get out of paying you. It may just delay payment.
Very good, Phyllis. So in a situation like this, is it a good idea to continue to have dialogue? Well, for example, if you're the person who is obligated to make these payments, when is it an appropriate time to reach out to a bankruptcy lawyer like Phyllis, like you, to say, hey, I've got this issue. What should I be thinking of if you're the person who is charged with paying child support, alimony, or maybe in a divorce case, debts were allocated between the parties and maybe the husband isn't paying the debts that he was supposed to, and the creditor is knocking on the wife's door saying, hey, your husband hadn't been paying, you need to pay us. What can they do in that situation?
So unfortunately, a lot of times people do wait too late to talk to the bankruptcy lawyer. And it comes in the form of, I've just been arrested on a contempt order and I'm in custody and can't get out until I purge or pay the amount that's owed. And at that point, someone would seek bankruptcy protection, and then the judge has to let them out of custody as soon as that action is filed, and then it proceeds from there. But you gave some really good advice earlier when you said exhaust all your efforts at trying to work with the other party and their attorneys, if there's attorneys involved, to try to reach a solution. Make a good faith effort, because anything that happens, you need to be thinking, if this is going to go in front of a jury or a judge, and this whole story is going to be told to someone who's going to be making a decision on this case, how am I going to look? So every action that I take, am I looking like I'm making a good faith effort to make this payment? And if someone is doing that and they're paying very little or nothing at all, the judges will see if they have no ability to pay. It's pretty easy to look at pay stubs and bank statements and things like that, and to tell whether or not someone's making a good faith effort. And remember, in the bankruptcy context, the bankruptcy court has the power of the subpoena power to go in and audit and look at bank statements, retirement accounts, anything that they want to look at to make sure that what you're saying is actually true. So if you're saying you don't have any money and you actually do, well, that's going to get you in a lot of trouble. Now, as far as the co-debts go, if you are in a divorce and in the final decree, husband agrees to pay the joint American Express debt, and then subsequent to the final decree of divorce files for bankruptcy protection. Well, that husband is still on the hook to pay that American Express debt. The bankruptcy court will go ahead and discharge the husband of that debt, but the wife can then turn around and file a contempt action against the husband, saying you're in violation of the Superior Court order. Obviously, that's very expensive for both parties, so it's much better to address these things ahead of time. And it may be that before you actually file for divorce, you need to file for bankruptcy protection together, or maybe one spouse needs to file for bankruptcy protection. Because at the end of the day, if you are a spouse who is being awarded some type of support, you want your ex-spouse to be able to pay that support. You don't want them to be so saddled in debt that they're unable to meet their obligation to you. So while sometimes ex-spouses get upset when a spouse files for bankruptcy protection, it may actually end up benefiting that spouse.
Well, Phyllis, so it sounds like what you're saying is there may be situations where a husband and wife are going through a divorce, and while they're going through a divorce, they may need to reach out to you to say, hey, does it make sense to file a divorce now before we even finalize the divorce?
That's correct, Bill. And need to understand that if that were to happen, that it would stop the divorce action in its tracks. So it would just kind of delay that and stall that. But that's okay. If it's in your financial best interest, you get you file for bankruptcy together. And then once the bankruptcy has been resolved, then you proceed on with the divorce. A situation where that might be beneficial is when you have high income people, either combined income is high or one spouse has got a high income. You may be in a situation where separately, if you file separately, you're not going to qualify for the Chapter 7 because you make too much money. But if you file together as a household and you include the children, and maybe even you're separated and you've got two households, well, then you may have enough deductions to take out of your income to make you qualify for the Chapter 7. And let me just back up so that that makes sense and tell you there's two types of bankruptcies. There's a Chapter 7 and there's a Chapter 13. In a Chapter 7, that's the most preferred bankruptcy filing, and that's because that's a liquidation and a discharge and there's no repayment plan. So it's like ripping off the Band-Aid and just getting through it. In the Chapter 13, that's a 5-year repayment plan. It's very difficult to get through. You can't miss any payments. Normally, the court sets that payment amount at an amount that's really too high and is difficult for people to pay. And that is why 75% of people actually fail in a Chapter 13 plan. So we'd much rather put you in a Chapter 7 and so you can, in a sense, walk away from all your debts. And we can get real complicated talking about exemptions, how you keep your house, how you keep your car, but that's all possible as well. But my point is that if you want to get into a Chapter 7, it may make more sense for you to file together so that you meet the income requirements in order to qualify for the Chapter 7.
So filing together, there'd be a higher income requirement for the husband and wife versus a lower.
It's based on household size. So if you are, if you're married, even if you're living apart, you know, some people will get separated and live apart, either on a trial basis or they know they're never going to live together again, but they're still married while the divorce is going on or while they're trying to decide what to do. The good thing about that in a bankruptcy context is that you can use both household expenses to deduct income. Because what the bankruptcy court is looking at is at the end of the day, after you pay all your expenses, what do you have left in disposable income? And if you have too much in disposable income, they say, well, you have enough to fund a Chapter 13 plan. We're not going to let you do the Chapter 7. So if you file together and the income requirements are higher, the threshold is higher, and you've got all the kids that you can take deductions on, then now you may qualify, whereas if you filed separately, you wouldn't.
Understood. Well, it sounds like, to summarize, it makes sense to reach out to legal counsel early in the process.
Yes.
It's almost like a ship trying to make a course correction. You want to do that sooner rather than later because it's a lot less effort to do it earlier than later.
Right. And you may decide, no, we need to get divorced first, and then one spouse needs to file. And when that comes up, of one particular situation where you would want to do that is, let's say that a married couple has a house that's got $200,000 in equity in it. Well, if they filed a bankruptcy together, they are going to lose that house. The trustee's going to sell that house and use the equity to pay off creditors. But if it's clear that the wife is going to be awarded the house in the divorce, and you're the expert in divorce, I don't know what the conditions would be, but we all know sometimes the wife gets the house. If the husband is the one with a lot of debt and he's really the one that needs to file for bankruptcy protection, it makes more sense to get divorced first, award the wife the house in the bankruptcy, in the divorce decree, then the husband files, and the bankruptcy court cannot take an interest in that house because it doesn't belong to the husband anymore. Now, generally speaking, you cannot transfer real estate within 4 years of filing a bankruptcy. It's considered a fraudulent transfer, an attempt to keep money from creditors. But when it's in a divorce context, it's okay. So that may be a way to protect an asset.
Well, Phyllis, it looks like we're getting close to our 15-minute mark. I want to invite everybody to reach out to me at Gentry Law Firm, 770-425-5573. And if they want to reach you, Phyllis, how do they reach out to you?
You can reach us at Phyllis at phyllislaw.com, or you can call us at 470-645-5835, or you can reach us on all the social media platforms at Phyllis Law.
follow us on social media. Well, all right. At this point, if anyone has any questions, feel free to type them into the chat box. We'll be happy to field questions from you. If you don't have any questions, there are a couple of other points I wanted to kind of raise with folks. One of them is when we suggest that you communicate with your spouse or your ex-spouse or the mother or father of your children that you have together, always be courteous. I can tell you many situations when I went to court with my client and my client was sitting on the witness stand being cross-examined by the opposing counsel because of truly horrible emails he or she had sent to the other side. And I had one situation I can remember in particular here in Cobb where the judge got angry at me, frankly, because my client was so angry and nasty with his ex-wife. So I think it's critically important that you be cooperative. You don't have to be nice, but you have to be courteous. Phyllis, do you ever run into that in the bankruptcy context?
Oh, absolutely. And the emails are really what gets people into trouble. And so I always advise all of my clients, as soon as they retain me, tone down the social media, because people tend to be quite aggressive on social media. And I always tell people that anything that you post on social media or put in an email or a text, assume that that's going to be published to the world. And if you're not proud of what you wrote, then you probably shouldn't write it.
Absolutely. And, you know, I go one step further and say, assume that anything you say to your ex-spouse is being recorded. Anything that you type in an email, type in a text is going to be repeated. And that you're going to be cross-examined and really, roasted on the spit at trial.
Right.
I've seen that and I've done that. Well, Phyllis, in any parting comments that you'd like to make? I have a couple of things I want to say, and then we can wrap it up here.
Yeah, sure. Thank you so much again, Bill. I have worked with you on a lot of cases, and I consider you to be an expert in the field, particularly with high asset divorces, and you are my go-to guy. And so I appreciate you including me on this. And I also just wanted to take this opportunity to thank the citizens of Cobb County, my former clients, current clients, all my colleagues for voting me the best bankruptcy attorney again for the second year in a row. I am really worried about my fellow man in these troubling times right now, and a fear that a lot of people are going to have to seek bankruptcy protection or some type of debt settlement negotiation. And I'm here and ready and happy to help anybody that needs my help.
Great. Well, we're going through a tough time right now. Tempers are frayed and finances are tight. But remember, this thing will be over soon, and there's a new dawn coming. Start taking action today to create that new and better future that awaits. All right, well, at this point, I think we're going to sign off. Stay well, and we'll talk again soon.